The freedom to carry firearms is protected under the Second Amendment of the U.S. Constitution. There has been a lot of discussion over this right, especially in places with strict gun laws. In this regard, Boland versus Bonta is a crucial court case that contested California's severe gun restrictions, previously known as the Golden State of gun control. What is the California handgun roster, and how big is it really? The roster of handguns certified for sale is a list of handguns on the California Department of Justice's website that can be manufactured in California, imported, sold, purchased, lent, etc. In other words, the DOJ largely controls what handguns are legally obtainable. Officially, the government says it's not restricting a person's ability to purchase a handgun because there are hundreds of such models on its roster. Even a cursory examination of the roster shows many of these handguns are actually duplicates. In other words, the number of handguns the DOJ says is certified for sale is not the actual number of unique firearms Californians can choose from. This begs the question, how many unique handguns are actually on the roster that people can choose from, and how to get back the lost control on the gunning issue? About one-third of the roster's total listings are comprised of makes and models that don't offer consumers substantive and material choices in the physical attributes, function, or performance of a handgun relative to another listing of base models. A federal judge in San Diego has placed an injunction on California's Unsafe Handgun Act as part of the ongoing Rena versus Bonta case, which challenges the state's stringent laws governing handgun ownership. Judge Dana Sabra's April 6 ruling blocks 4 provisions of the law on the grounds that it violates the Second Amendment, which means the California-approved handgun list may someday be history. California's existing Unsafe Handgun Act, which took effect in 2001, maintains a roster of handguns that are legal in the state based on increasingly exclusionary criteria. This law has meant Californians have been limited to older handgun models. New guns and new iterations of existing models are not added to the approved list and are therefore illegal. District Judge Cormac Carney ruled that no handgun available in the world has all 3 of these features, and that the technology effectuating micro-stamping at a broad scale is simply not technologically feasible and commercially practical. The Bruin decision says there is no justification for laws restricting the public carry of weapons that are unquestionably in common use today. Every law that is passed must align with the Constitution as it was written at the nation's founding and expanded following the Civil War, steadily expanded as the list of handguns certified for sale in California dwindles. The counter-argument from the state is that the California-approved handgun list is on a solid legal footing. After all, certain firearms cannot be in common use if they're banned, and they can be banned if they're not in common use. The injunction is good news for California's gun owners and the Firearms Policy Coalition, the pro-2A nonprofit organization behind the lawsuit. The Second Amendment has been a hot topic in recent court cases, partly because of the U.S. Supreme Court's Bruin decision, which ruled that New York had overreached in its efforts to restrict concealed carry permits. Individuals and advocacy groups are responding by challenging other state laws that they believe violate the Second Amendment, and Rena versus Bonta is a step in the right direction for residents in California. In 2007, California became the first jurisdiction in the nation to enact legislation requiring firearm manufacturers to incorporate crime-solving micro-stamping technology in at least some firearms. Micro-stamping technology causes a firearm to etch a unique microscopic code onto ammunition cartridge cases when the gun is fired that identifies the firearm's make, model, and serial number. This technology could enable law enforcement to match cartridges found at crime scenes directly to the gun that fired them, similar to the way an automobile's license plate may be used to identify a vehicle's make, model, VIN, and registered owner. Signed by then-Governor Schwarzenegger, California's Crime Gun Identification Act of 2007 requires all newly developed models of semi-automatic pistols sold by licensed dealers in the state to be designed and equipped with micro-stamping technology. According to the Crime Gun Identification Act, this requirement would take effect as soon as the California Department of Justice confirmed that several gun manufacturers could use micro-stamping technology without being constrained by any patent constraints. In May 2013, the DOJ gave that certification. The gun industry, however, has defied this legislation by refusing to release new semi-automatic pistol models for sale in California, since this requirement only applies to new semi-automatic handgun models. Instead, the industry has continued to market new versions of older semi-automatic pistol models without contemporary safety features while attempting to undermine the state's public safety regulations through litigation in state and federal courts. Previously, California generally required newly developed semi-automatic pistols models to incorporate a micro-stamping mechanism in at least 2 places on the interior of the firearm. In 2020, California passed new legislation to address industry obstruction and ensure more handguns certified for sale and manufacture in the state come equipped with basic life-saving consumer safety features as well as a micro-stamping mechanism. This legislation now requires the California DOJ to delete 3 older, less secure semi-automatic pistol models from its list of firearms that are authorized for sale in California for each new certified micro-stamping model after it took effect on July 1, 2022. This new law was intended to simplify compliance for the firearm industry and ensure that more commercially available handguns over time become fully compliant with California's contemporary gun safety laws by requiring new semi-automatic pistol models to micro-stamp ammunition cartridge cases from a single location on the interior of the firearm as opposed to from 2 locations. Bruin voided New York's requirement that concealed carry permit applicants demonstrate proper cause or a special need for self-defense. The decision also struck down May issue permitting, which gave authorities the discretion to deny permits based on subjective criteria that go beyond basic requirements like a background check. Most significantly, Bruin rewrote the methodology lower courts deferred to when evaluating the constitutionality of gun law, prescribing that it must have a well-established analog in American history. Specifically, the 77-year span from 1791, when the Second Amendment was ratified, to 1868, when the 14th Amendment was ratified. Within this framework, judges can no longer consider the real-world effects of gun regulations like violence reduction. More than half a dozen states have reassessed their concealed carry permitting laws in the wake of Bruin. Police and prosecutors have reevaluated their policies as well. On August 19, 2022, the New York City Police Department issued guidelines for concealed carry applicants to resubmit their applications if they had been denied because they couldn't demonstrate proper cause. These applicants must attest that they are familiar with state gun laws, submit a statement saying how the handgun will be secured, and describe how they have had training or plan to receive it. They have until October 18th to reapply. In the meantime, Attorney General Rob Bonta directed permitting agencies to stop requiring a demonstration of good cause in order to obtain a concealed carry permit, as it was now unconstitutional and unenforceable. He said they could still use other gauges of suitability like good moral character and suggested criteria for determining whether an applicant qualifies, including social media searches, character references, a history of racist behavior, financial stability, and honesty and trustworthiness. Bonta also said that permitting authorities can still ask why an applicant wants to carry a gun, even if the answer is no longer allowed to factor into their decision. The Second Amendment to the U.S. Constitution reads that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. But the question is if this gun roster is still valid or not. California's Department of Justice is allowing a plethora of handguns certified for sale by licensed dealers to be no longer valid beginning January 2022. Many of the 812 handguns listed on California's Department of Justice website as handguns certified for sale, including Beretta 92FS, Browning 1911, and Glock 19. This means that many of the handguns that are legal for civilians to purchase from a federal firearms license dealer may not be legal to purchase moving forward. We're waiting to see what potential actions come from the California DOJ, if there will be a renewal for those guns set to expire, and how it'll be enforced. As of now, there are no indications that the California DOJ is set to act on those guns that are set to expire. We will continue to monitor this issue and will provide updates as soon as they're available. Remember to subscribe to the channel for more blues from the world of firearms. This case perfectly captures the challenges of striking a compromise between upholding constitutional rights and reducing gun violence. The country is eagerly watching the legal dispute as it develops to see how the court's ruling may alter the outlines of gun control regulations not only in California but also nationwide. Click on the video links popping up for more interesting content, and we will catch you there in a minute.